Plus Freeman, on behalf of Jamie Foxx, she's standing here, am I right?
Your name?
Jamie Foxx.
All right.
We're starting with a bond violation situation where the courtroom tone is deceptively calm, but the stakes are simple: freedom versus custody. Judge Simpson is about to do what judges do in these moments: stress test credibility. Not, "Are you sorry?" but, "Are you safe on release, and are you telling me the whole truth?" And notice the strategy from defense right away. Full admission, no dancing around it, plus a pitch for strict alternatives, daily testing, house arrest, whatever you want, because voluntary accountability is the only currency that buys leniency in a bond violation hearing. Also pay attention to the timeline mechanics here. The court is setting the next date first, then dealing with the bond problem second. That's not random. It's the judge organizing the case, where it's going next, and whether the defendant will even be out long enough to show up. And the moment you hear prescription versus street situation, you can feel the courtroom trying to separate two issues: what's legally prescribed and what's a violation of bond conditions. Because even if something is prescribed, bond conditions can still require disclosure, consistent testing, and zero surprises. So the question becomes, is this a one-off lapse with real accountability or the start of a pattern? And in a courtroom, patterns beat promises every time. Stay locked in, because this video has two defendants, two bond violations, and two completely different ways a judge reads, "I swear it won't happen again."
So we wanted to adjourn this out, I think. Is that correct? First of all,
That's step one.
step one. March 6th, 13th. Which one would you put?
13th, Your Honor. On the 6th, that might be otherwise occupied.
That's what I thought. Probable cause conference will be adjourned to March 13th, 2025, 9 a.m. All right. And then as to the bond violations.
I'm going to talk to Jamie at length about this, and she just doesn't feel like she should deny the test. She feels like she should tell the court that she's made a mistake and she's apologetic, and she will test daily, house arrest, whatever you want. She'd like to avoid incarceration, but she has been clean for months, and she made a mistake. Correct?
Yes. Yes, sir.
Why?
I just made a bad decision.
Or you believe that you can not make any more bad decisions?
Yes. I guarantee I will. I can test every day.
Could you test today?
Yes. And I tested yesterday too, just because it was my...
You have a prescription for Adderall?
I do.
And I did confirm that she has a prescription that she fills at the pharmacist. It's not a street situation.
This is the key framing battle: mistake versus excuse. Jamie is admitting the bond violation and trying to keep credibility intact by volunteering extra structure, daily testing, house arrest, anything to avoid incarceration. Judge Simpson responds like a judge who's heard 1,000 versions of "it won't happen again." He drills down to decision-making. Why? Isn't curiosity, it's accountability. Because if the why is fuzzy, the judge assumes the next bad decision is already loading. The prescription detail matters, but it doesn't automatically solve anything. The court is listening for consistency. Was it disclosed? Is it properly documented? Does it match the test result? And does the defendant's behavior line up with someone following conditions? When defense says it's filled at a pharmacy and not a street situation, that's an attempt to reduce the judge's fear factor. Less drug use spiral, more technical violation.
So you're admitting to the bond violation?
Yes, sir.
Anything you want to say before I sentence you?
I'm just sorry, Your Honor. I promise I won't make any poor decisions.
You in jail till the 13th. What I'm going to do is I'm going to sentence you to 7 days in the Washtenaw County Jail. You'll go to there, and then your bond will be reinstated. Defendants remanded.
Is the court going to change the testing frequency, or will it continue?
Yes, and I am going to order that defendant is to test 2 times per week random.
This is classic judicial calibration. Punish the violation, but preserve the case's forward motion. Judge Simpson isn't doing a full "you're sitting until court" revocation. He's doing a defined, limited jail sanction, 7 days, then bond reinstated. That's the court sending a message without blowing up the entire release plan. Translation: I believe you violated and I'm not letting it slide, but I'm also giving you a pathway back out if you comply. And the testing order is the real lever. 2 times per week, random, is designed to close the loophole of I can time my behavior around scheduled tests. Random testing is compliance pressure. It's also the judge quietly saying, your word isn't enough anymore. Verification is mandatory. Also notice how quickly the courtroom moves once the decision is made. That's intentional. A judge doesn't want a long negotiation after a ruling because the longer it drags, the more it turns into storytelling instead of compliance. The decision is clean. Consequence plus stricter monitoring.
She's going to take it today. You're going to be
Right
out.
now?
You'll be out in about 5 days.
Thank you, Miss.
Thank you, Aaron.
Thank you. All right.
Thank you, Judge. My understanding is this is a case that Mr. Walters had previously asked to adjourn to seek new counsel, to retain counsel. He has not been able to do that this time. I'd ask for a 3-week adjournment so that he and I can sit down and talk, go over his case, and see about possible resolution, Your Honor.
Adjourn it, but what about his bond violation?
Yes, Judge. As it relates to his bond violation, I did speak to Mr. Walter about it in the hallway. Mr. Walter did say he was aware of the THC positive. He said he asked community corrections to send that off for further testing. He paid the $30 fee for that, as well as went to the therapeutic center that does his additional drug testing, and they did a second test.
When?
Within 24 hours of the positive test you received there, and he's expecting a result from them any day now. If the court wants to have those results in the near future, I'd ask the court to consider just adjourning it 1 week.
Well, I guess my question is he saying it shouldn't be in his system at all?
That's what he's saying, Your Honor.
Yeah, I did not knowingly ingest THC, but I do have a medical card, but
You have a medical marijuana card?
I do. It may need to be renewed, but I do have one. Oh,
This says you report not having one.
I think it's expired, Your Honor. I don't think it's valid. I think it is expired, I believe, Your Honor.
Now we switch defendants, and the vibe changes immediately. Jamie's strategy was ownership. Jeremy Walters' strategy is denial. I did not knowingly ingest THC, and that's a dangerous hill to die on if the numbers don't cooperate. Judge Simpson asks the most fatal question for this kind of defense. So you're saying it shouldn't be in the system at all? Because once you say yes, you're not arguing about a small slip. You're claiming the test result is essentially wrong, contaminated, or impossible. Then the medical card issue lands like a brick. A valid card might explain lawful use in some contexts, but it doesn't automatically override bond conditions, and here it's apparently expired anyway. That matters because it undercuts the I have a legitimate reason angle and turns it into I have a story that doesn't match the paperwork. Judges hate gaps between story and record. Also catch the judge's sarcasm-laced disbelief when the defendant implies THC snuck into his system. Judge Simpson isn't mocking for entertainment, he's signaling a credibility deficit. In bond violation hearings, credibility is oxygen. Lose it, and everything after that sounds like excuse-making.
So I don't think he has a valid card. He may have a physical card, but not a valid physical card, Your Honor. My understanding of talking to him, I said my first time talking to him, Your Honor, he says he did not use any THC. And that's why he paid for the additional testing. And that is why he went and got the second test within 24 hours. So he should have some verification.
So you were just somewhere and this THC snuck into your system?
I don't really know how to.
Really?
I would.
No, hold it. So Mr. Feaster will explain to you how I am.
I did
Yeah.
already.
So I just want to know, is that the story you're sticking to tell me?
Well, I
What he's saying is, like we talked about in the hallway,
Mhm.
if you did accident or choose to use marijuana in violation of your bond, it is best to tell him the truth today
Right.
and not say you didn't do it if you did do it. If you didn't do it, then you could.
And I didn't do it.
Okay.
I'm
So
100%
if we-
confident that.
If
But I don't
we
know.
tested you today, your levels would go down for winning that other test.
Yeah, or it'd be non-existent.
Or non-existent?
Yeah.
Okay.
I'm happy to.
Oh, yeah. Oh, you can be happy with that. You're going to go over and get tested.
All right.
And we'll see what the results are. And then I'll make my decision as to what I'm going to do with them.
Thank you, Judge.
This moment is Judge Simpson taking control of the narrative. When a defendant denies THC, the judge doesn't want a courtroom debate based on vibes. He wants data. Go test is the judge saying, we're not litigating hypotheticals, we're verifying reality. And the warning underneath it is obvious. If the result confirms use or shows rising levels, your denial becomes an aggravating factor. There's also a procedural detail people overlook. The court and community corrections logistics. They're confirming he has money to test before sending him. That sounds minor, but it matters. Missed tests, refused tests, couldn't pay, and delays can become a compliance pattern that looks like avoidance. When testing is a bond condition, failure to test reads like failure to follow the court, even if the underlying case hasn't moved. And notice how the judge frames the decision. Then I'll make my decisions what I'm going to do. That's the court keeping discretion open until the evidence locks in. It's also a subtle offer. Your best chance right now is to stop talking and let the test either support you or expose you.
So you're going over the community questions right now. What Judge is telling you.
Yep.
I'm sorry. I noticed on the bond violation report that when the defendant went to do his initial intake, he said he didn't have money to test, which is why he wasn't tested that day. So we just confirmed that he does have money before he sent over there to prevent us having to come back and everything.
Do you have the funds to be able to test today?
I do.
He does, Judge.
Okay.
Thank you, Your Honor.
You're welcome.
Appreciate it.
All right.
Okay.
Okay.
He can head over and you'll let them know he's on his way? All right. Go test. Thank you. Court calls the case People versus Alyssa Reese. You ready, Mr. Feaster?
As ready as I'm going to be, Judge.
Court does call the case People versus Jeremy Walter.
Ashley Lonnie for the people.
Torshio Feaster, Assistant Public Defender. On behalf of Jeremy Walter, to the podium, please.
Jeremy Walter.
Thank you, Judge. I did. Thank you for giving Walter the opportunity to go to community corrections and to have his another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up. So
skyrocket would probably be a word.
well, yes, Judge, that would be accurate.
Okay.
My client, I spoke to him about this again and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
Can I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the test on Tuesday, is our first test.
Correct.
The defendant was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127, he missed. 24, he missed. 214, he refuses. 218, we finally get a test and it's positive, and today 220, the test is increasingly positive. The reason that I'm particularly concerned in this case is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges can be really disruptive.
This is where the case stops being maybe and becomes pattern. The defense just told the court the levels went up from February 18th to February 20th. Rising levels do not match the story of accidental exposure, or it must be a mistake. And when the defendant stays adamant anyway, Judge Simpson is now evaluating 2 violations at once, violating bond conditions and violating the court's trust with an implausible explanation. The prosecutor's timeline is brutal. Not testing, unable to test, missed dates, refused, then finally a positive, then an even more positive. That sequence makes it look like avoidance until forced. And the prosecutor adds an extra layer, mental health concerns. That's not character assassination, it's risk framing. Courts get especially cautious when substance use and mental health instability might interact, because the concern isn't just compliance, it's safety, predictability, and whether the defendant can follow orders while on release.
I am very concerned about the defendant and his behavior while on bond. And I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's got in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here and he's got an opportunity to tell me something's going on. And he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels and it's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was, because of my bond stipulations and the no contact order with my parents, which is where I was living before, I was living in a place that I realized was not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car, and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of the nonprofit that I volunteer at. But I made that significant change in order to remove myself from a potentially hazardous situation. I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him so that he can hopefully see you again and have new counsel present for that next court date.
Probable cause conference will be adjourned to February 27th. I'll set it to next week, 2025, 9 a.m., whereas his invite indicates at this time, given the positive test, I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. The defendant is remanded.
Thank you very much, Judge.
Judge Simpson makes the deciding factor explicit: truthfulness. The court can sometimes work with relapse, mistakes, and even technical violations if the defendant is honest and shows a plan to comply. But when the judge concludes the defendant is intentionally violating and not telling the truth, the release decision collapses. Bond is built on trust plus verification. The verification here, rising THC levels, contradicted the explanation and the trust took the hit. So the final ruling is clean. Probable cause conference adjourned to February 27, 2025 at 9 a.m., and the defendant's bond is revoked. He's remanded. That means custody now, not later, because the judge believes continued release is unsafe or unreliable under the current conditions. Bigger takeaway: compare the two defendants. Jamie admitted the violation, apologized, offered structure, and the judge imposed a defined sanction with reinstatement and stricter testing. Jeremy denied, the evidence got worse, and the judge read it as intentional non-compliance plus dishonesty, so the result is remand. In bond court, the difference between sanction and continue versus revoke and remand is often one thing: credibility under pressure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.